Hi, my name is Eric Willison. I'm going to be talking to you today about gun control and about the Second Amendment. I'm going to do this over the course of a few linked videos. I was going to do this all in one big video, but I find that it's best to break it up a little bit. Sometimes most people look at a 45-minute video, they'll just pass on it. And if I break it up into three, if you want a 45-minute video, you can watch all three. So we don't lose anything doing it that way. So if you don't hear some arguments that you wanted to hear in the first video or the second video, stick around. Maybe you'll hear them in the third video. The second one is that I want to talk to you about is that you may have heard some of these arguments before. As a matter of fact, I know you'll have heard some of these arguments before. But I'm hoping to give you some new stuff too. But I do want to repeat the older stuff as well, because younger people just coming into this debate haven't heard all of this stuff. So bear with me. I'm going to give you some basic arguments as well as maybe some more complex and some more some arguments that you maybe haven't heard before. I'm going to be presenting arguments from both sides a little bit, but in the interest of full disclosure, you should know that I'm a big Second Amendment fan, and that I think almost all gun control legislation is unconstitutional. So I'm going to be laying my cards on the table up front. Understand that. If you're looking for somebody who's going to give you more of a fair presentation of a gun control argument, I'm sure there's other videos out there. You may be wanting to hear that so that you can strengthen your gun control arguments. Or you may want to hear that because you're a big Second Amendment fan and you want to better understand the arguments of the other side. So maybe one of the weaknesses of this video would be that I don't really give a fair hearing to the other side, but I'm here to tell you that up front. And lastly, I'm going to be making some legal arguments on gun control, but I'm not going to be getting into the Supreme Court cases like those that are leading up to Heller, the Heller decision itself from 2008, nor the Heller and its progeny decisions. I'm going to be giving you arguments about gun control, but not Supreme Court arguments, things that have been argued back and forth in the Supreme Court. Those arguments I'll do in some other set of videos, so understand that. Now, any argument that is going to be about the Second Amendment, we got to start off with the text of the Second Amendment, because that's where the gun controllers really come in, is they try to tell you, you guys in your Second Amendment, but you ignore the first part of it. Well, here's the whole part of it, the whole of it, I should say. Quote, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Now, this well-regulated militia and the security of a free state, the gun controllers say that all the Second Amendment does is it authorizes the government to form the National Guard. Does that sound right to you? Let's use our critical thinking skills as we analyze this text. It does say, a well-regulated militia being necessary to the security of a free state, comma. It doesn't say a well-regulated National Guard. It says a well-regulated militia. Now, the militia is not the National Guard. The militia is a group of people who comes together in their local community to drill and practice the military arts with their weapons to defend that local community from threats to the local community. But that's not the National Guard. That's the militia. That's the Minutemen, if you will, from the American Revolution. That's people in your local area. But beyond that, let's say that the militia was the National Guard, even though today there are still militias, and today there are National Guards. The Constitution is a federal document. It sets up the federal government. The National Guard is a state-run entity. Why would the federal government, why would its founding documents be interpreted so as to give the power to lay out and set up a state-run entity? That would be found in a state constitution. Similarly, there's no federal militia. Militias are local. So this idea that this is for the government to set up, the federal government to set up a militia, it doesn't make any sense if you consider the document that you find the Second Amendment in. Now, it talks about a well-regulated militia, and I've even heard Alan Dershowitz talk about how it's a well-regulated militia. But that begs the question, well-regulated by whom? The federal government? I don't think so. It doesn't say well-regulated by whom, so I don't think that really gets you anywhere as a gun controller. Now, the Second Amendment proponents of a broad reading of the Second Amendment as an individual right, they've got some arguments that I think are a lot more convincing than this idea that the Second Amendment merely gives the government the power to arm itself. Number one, governments don't have rights. People have rights. What governments have is powers. So, again, looking at the text, first it says, the right of the people to bear arms shall not be infringed. People have rights, not governments. Now, we're not talking about, the people will say, there are gun controllers who will say, well, the people, that means the government. Like the people versus Jones or the people versus Smith in court cases. No. We know that that's not the case because, again, look at the full text of the amendment. It talks about the security of a free state and then goes on to say the people's right to bear arms. If the people and the state were the same thing, then why would you use different terms? Why wouldn't you say, if people meant government, the security of a free people instead of the free state? Also, look at the text, the very first words of the Constitution itself. It says, we the people. And what are we the people doing? Forming what? A government. Well, how can something form itself? It can't. The people are distinct from the government. As Ronald Reagan once said, famously, we are a people with a government, not the other way around. And quite right, too. Now, let's look also at the structure of the Constitution and the amendments. The structure of the body of the Constitution sets up the government, the federal government, much like a recipe sets up a cake for a baker, much like architectural plans set up the building for the architect. This body of the Constitution sets up the Constitution, sets up the government, the federal government, okay? Article 1, you got the legislature. Article 2, you got the executive and the president. Article 3, you've got the judges. So, and so on. Now, at the end of the Constitution, after we're all done with the articles, we've got these amendments. Amendments are changes. And the first, depending on how you describe it, the first 8 rights, the first 8 amendments of the Constitution. Some people would say that's the Bill of Rights because that all deals with the individuals. And then some people say that's the first 10 because the last 2 deal with the any powers not given to the federal government remain with the states. Any powers not given to government remains with the people. Those, individual, I'm not sure if those are individual rights or not, doesn't really matter. The point is, whether it's the first 8 or the first 10, the Second Amendment is found within both subsets. Now, if the First Amendment indisputably guarantees the right to free speech, if it indisputably guarantees the right to religion, the right to be free from religion, the right to petition your government, the right to assembly, if you've got that, and then let's say you go under the Third Amendment, you got the right of the people not to have troops quartered in their houses. The Fourth Amendment, the right of the people, the individual not to be subjected to unreasonable searches and seizures. The Fifth Amendment, the individual's rights to due process, the individual's rights against double jeopardy, so the prosecutor can't keep trying you over and over and over again for the same crime, trying to get a result where he finally convicts you. The Sixth Amendment, the right to have an attorney. The Sixth Amendment, the right to confront witnesses against you. Seventh Amendment, right to a jury trial. The Eighth Amendment, the right against cruel and unusual punishment. All these are rights. Why, in the midst of this enumeration of rights, of liberties, why would we suddenly stick in this power of government to set up a National Guard or a militia? We already have that in the body of the Constitution. The Army-Navy clause says that the Congress can fund and set up an Army and a Navy. And then there's a necessary and proper clause that certainly would govern whether they can have some part-time forces like a Guard or a Reserve, or even some sort of a part-time federal militia, which there never was and never will be. But the point is, the body of the Constitution already gives Congress the power to set up the armed forces. We don't need a duplicative amendment to say the same thing. So, in ordering the amendments, the people who enacted them thought freedom of speech, freedom of religion, freedom from religion, freedom of the press, all those sorts of things were that was the most important amendment. Why would the second most important thing be duplicative of the Army-Navy clause? It doesn't make any sense. It doesn't make any sense to have a duplicative amendment giving a power to a government right in the middle of an enumeration of the rights and liberties of the people. It just doesn't make any sense. Also, it's important to remember that the Second Amendment talks about how the right to bear arms is not created by the Second Amendment. It shall not be infringed. What that means is the people already had the right to bear arms before this Constitution. It was already a part of their rights, and it shall not be infringed. So, it pre-exists the Constitution, and the Constitution does not take it away. In fact, it specifically says it won't take it away, it will not infringe it. Another argument that the leftists and the gun controllers always want to leave out is that they'll try to get you in an argument to admit that there's an ambiguity in the Second Amendment. They say, at least you'll admit, because of that first part of the text where it says, and again I'm going to quote, a well-regulated militia being necessary to the security of a free state, you have to admit that at least there's an ambiguity there, right? Well, no, as I've just gone through, but let's say, for the sake of argument, that there is an ambiguity there in this document. Let's go with it for a bit. The Constitution, as I said, it sets up our government. It is the supreme law of the land. Now, when the government passes laws, it has to speak clearly. It has to tell the citizenry what the law is and what the law is not. And from that, we get what's called, in law, the rule of lenity, Lenity. In some states, that's codified. In some states, it's just a case law construct. But the rule of lenity says that if a statute is ambiguous, meaning that after the judge hears party A say, this statute means this, and the judge says, that's a reasonable interpretation, I can see where you get that. And then he hears party B say, no, Your Honor, the statute means this. And the judge says, I can see that too. That's also a reasonable interpretation of the statute. Then what we have is an ambiguity. And when the statute is ambiguous, it is construed strictly against the state, and it is construed liberally in favor of the individual. So the rule of lenity comes in on the side of liberty, and it should be construed liberally in favor of the individual rights of the people. Now, I got a lot more on this. We're going to get into it in videos 2 and 3.